The Honorable Court of Appeals for the 7th District of Texas is now in session.
Be seated. The next case on this morning's docket is cause number 0723-00064-CD, Sunday Sky Properties Incorporated versus Independent Bank. Who will be arguing for appellant?
Jeremy Tucknell, Your Honor.
And for the appellee?
Michelle Robertson, Your Honor.
Thank you. You each will have 20 minutes. The appellant has a 5-minute rebuttal. And if you're ready, you may take the podium.
Justices, good morning, and may it please the court. My name is Jeremy Tucknell, and I represent Sunday Skies Property Incorporated, the appellant in this case. Will the court like a brief recap of the procedural history in this case?
However you'd like to use your time.
Thank you. This case is on appeal from the 481st Judicial District Court of Denton County. Sunday Sky has appealed a final order which dismissed Sunday Sky's declaratory judgment and breach of contract claims pursuant to 166 subparagraph G and 248 of the Texas Rules of Civil Procedure. Both rules allowing the trial court to make legal findings before a jury commences. In that final order, the court made 2 erroneous legal findings to support the dismissal of the underlying case. First, that Sunday...
Let me ask you this.
Yes, sir.
You're not contending that either rule was, you may say that they're inappropriately applied in this case, but you're not making the legal argument that the rule was misused, that trial judges should not use Rule 248 for this reason or anything like that, right?
No, Your Honor, nothing like that. I think the rules prove an important role in allowing trial courts to effectively manage their docket if there are legal issues that need to be addressed before a jury is impaneled. It's absolutely imperative that the courts determine those legal issues before the jury is allowed to make the findings of fact.
How, in other cases, when we are looking at sufficiency of evidence, for example, under summary judgment practice, motion for directed verdict, the objections to a jury charge, J&OB motions, or motion for new trial, we're all applying one set of legal standards to assess the evidence in all of those cases. What is the standard you think is the correct thing a reviewing court should do under 166G or 248?
So, Your Honor, in this case, I believe the proper standard is de novo. I believe, Your Honor, that Rule 248 of the Texas Rules of Civil Procedure states that when a jury has been demanded, questions of law shall, as far as practicable, be heard and determined by the court before the trial commences. If this were a mixed question of law and fact, the standard would be abuse of discretion, where this court would defer to the trial court's factual determinations, if supported by the evidence, and review the legal determinations de novo. Now, in this case, there were no factual determinations made. Those factual determinations were usurped from the jury, in this case, by the trial court judge, and the trial court had made the legal determinations that it made in its final order. Because the jury was demanded to make determinations of fact, the court had no factual determinations to make, and the legal determinations made by the court, or the trial court, must be reviewed de novo, akin to a motion for summary judgment. Now, the facts of this case, Your Honor, or Justices, are that in August 2017, Yossi Verrazano...
You did not suit your deck action. It also was dismissed by the 248?
Yes, Your Honor. There were 2 separate deck actions. The one deck action was asking that the documents, as taken together as a whole, represented a valid enforceable contract. There was a second deck action where we were asking the trial court to enforce that original contract and essentially give Sunday Sky the property back. We dismissed that second deck action.
That was a specific performance?
Yes, Your Honor. And so we non-suited that deck action, attempting to make the claims a little bit more understandable to the trial court judge in order to move forward on our pretrial motions hearing, which is what this 166G and 248 motion were. Whereas it was a pretrial hearing to render down the facts for trial.
What essentially we're talking about here is whether the representative of the trustee at the foreclosure sale is bound by giving your client extra time to go produce the funds for the sale, right?
No, Your Honor, I actually don't believe that that's the question we're dealing with here. The question we're dealing with first is whether or not the documents taken together as a whole satisfy the statute of frauds under 26.01 of the Texas Business and Commerce Code. The underlying aspect of that discussion would be section 51.075 subparagraph F of the Texas Property Code.
And are you saying that that's the question before the court because that's what the court said in Key?
Yes, Your Honor. What I'm saying, what Sunday Sky is kind of arguing, Your Honor, is that the subsequent oral agreement is irrelevant to the contention that the documents taken together satisfy the statute of frauds. Now, the Heck case out of the Federal Fifth Circuit Court of Appeals analyzed and discussed the history of 51.075 F of the Texas Property Code. And in that case, the Fifth Circuit had enough evidence in the record to show that at a non-judicial foreclosure sale, a bidder won the property with the highest bid, requested an hour to return with the funds. The trustee said, you have 20 minutes. The highest bidder wasn't able to return in time to produce the funds. And the trustee subsequently restarted the bidding and sold the property to another case. Importantly, what the Fifth Circuit, the Federal Fifth Circuit Court of Appeals, analyzing Texas law found was that the oral agreement to extend the time for production did not modify the contract itself, represented in the deed of trust, the notice for sale, and the narrative of the substitute trustee sale. What it did was it just provided a condition on the time of payment. And that condition could be a completely separate agreement. Now, in this case, there were no factual determinations made as to what the actual oral agreement was. There was two Sunday Sky representatives, Mr. Barzani and Mr. Kimmel, who both testified at their depositions that the substitute trustee gave Mr. Barzani until 1:30 to arrive at the Denton County Courthouse to provide his funds, which he said he had. When he arrived, he explained to the substitute trustee that he had $500,000 in cashier's checks to pay for his winning bid of $311,000. Mr. Zhang Ping Tang was a disinterested third party who was also at the original bidding process for the property, who also testified at the deposition that he heard the substitute trustee give Mr. Barzani until at least 1:15. The testimony from the substitute trustee was that he didn't give any additional time for Mr. Barzani to arrive, and so he restarted the bidding restarted the bidding process at 12:58. 12:58 p.m. Which was in violation of the narrative he read aloud, in which he stated that the winning bid would be allowed until 1 p.m. to arrive with his winning bid. So in this case, Your Honor, while Heck provides the outline or the analysis that the oral modification does not negate or does not affect the original contract represented by the deed of trust and the notice for sale, however, it's simply a condition for payment. and that condition for payment can't be used to negate the memorandum of documents taken together as a whole, which clearly satisfy the statute of frauds, according to the Key case.
Well, I agree with you that the underlying documents probably do cover the statute of frauds. We've got other cases in other settings, though, that involve options, rights of first refusal, and the courts have uniformly said in all of those cases that the statute of frauds does apply, and that you have to have a writing for all of those. How is this case different from a situation where there's an option, for example? There's a situation where a buyer is interested at some point in possibly purchasing the property if they're able to get there within a certain deadline with presentation for payment. And in those cases, the courts, including the Texas Supreme Court, has said that that's a statute of frauds issue.
So, Your Honor, in those situations, we would respond in saying that the difference would be that the foreclosure landscape is much different from a normal real estate purchase agreement where a statute of frauds might apply. The Heck case goes into the analysis of pre 51.075 of the Texas Property Code, where the Texas law held that trustees had a duty to provide a winning bid to allow for a reasonable time for them to produce the funds. In 2007, 51.075 F was written that demanded that the winning bid was due and payable upon the winning bid immediately, essentially. And this caused an incredible amount of problems in the foreclosure landscape, where many foreclosure sales would all of a sudden fall apart because the funds weren't available and weren't available immediately. So in 2009, 51.075 F was amended to allow the substitute trustee to grant a winning bidder a reasonable time as agreed upon between the parties to produce the funds. So I think that statute there provides an avenue that allows the difference between an options contract, which is very clear that needs to be paid before the option runs, or a foreclosure sale where there are multiple bidders, you're not sure what the final price is going to be. You may show up at a foreclosure sale with $250,000 in your pocket, and the winning bid is $255,000, and you can run to the bank really quick and grab $5,000 out of the ATM and run back. So, Your Honor, the difference would be the specific section in the landscape of the foreclosure setting.
Was there a reasonable time agreed to in this case?
It's the factual issue that just wasn't determined by a jury, Your Honor. There, as I explained, there are multiple different testimonies. The two Sunday Sky representatives stated that they were given until 1:30. The disinterested third party stated that he heard that the substitute trustee gave until at least 1:15 p.m. The trustee itself said, I never gave any extension of time. However, even if he had given no extension of time, Your Honor, it would be a breach of the only agreement he made with the bidders at the original bidding process. The narrative of the substitute trustee states clearly that he would give the winning bidder until 1 p.m. to arrive with the winning funds.
And what time did your client arrive?
Our client arrived at 1:13, Your Honor. And so by restarting the bidding again at 12:58, he negated any possibility for my client to arrive before the 1 p.m. Deadline that was in the narrative for sale. Now that we disagree and claim that the substitute trustee had given our clients additional amount of time to arrive from the Collin County Courthouse over to the Denton County Courthouse, and from the disinterested third party and our two representatives, he was given until at least 1:15 p.m. to arrive at the courthouse. And so arriving at 1:13, we think he would have clearly made it within the time period allotted by the substitute trustee. The second point of error that Sunday Sky would bring before this court is that the trial court erred in finding that Sunday Sky failed to tender the purchase price and therefore is not entitled to recover under the breach of contract claim. Texas law is clear on the definition of tender that the Texas Supreme Court has held that a valid and legal tender of money consists of production of the funds and offer to pay the debt involved. However, the concept of excusing pre-suit tender when such tender would be, quote, useless or futile has been recognized in Texas equity jurisprudence for over 100 years. The Texas Supreme Court has explained that while pre-cert tender may be excused, a plaintiff is still required to show that they are ready, willing, and able to perform at the relevant time.
Was there a production of funds here?
So that's another question, Your Honor. The DiGiuseppe case cited in the appellate's brief, the Texas Supreme Court case, 2008, parallels this case in kind of some significant ways. There, the issue was
Before you get into that.
Yes, Your Honor.
I think Justice Parker was asking you specifically to the record, what does the record evidence say actually occurred?
So the record evidence says, Your Honor, that Mr. Berrizani showed up at 1:13 p.m. and had discovered that the substitute trustee was filling out and executing paperwork to transfer the property to the second winner. Mr. Berrizani approached the substitute trustee and tried to explain to him, I'm here, I have the funds, I am, just sell the property to me, I had $500,000 in a cashier's check, I have the money, and the substitute trustee refused to accept it. There were questions as to whether or not Mr. Berrizani was required to physically force the checks into the substitute trustee's hand, and we believe that just is simply not the case under Texas law, that his attempt in telling the substitute trustee that he had the funds were enough to show that he was had the ability to tender the full amount of the purchase price.
So, but that's what the record evidence says, is that your client said, I have the funds, and the substitute trustee says, I'm not accepting them.
Correct. Yes, Your Honor. Now, the independent bank, the appellee in this matter, has cited Kirkman, which as reliance that Sunday Sky's failure to tender negates their claim for breach of contract. And the Kirkman case is clearly distinguishable from the current case before the court here. Now, in Kirkman, the winning bid Kirkman had the winning bid at a non-judicial foreclosure sale, and which adjourned at 11:15 a.m. It was then reconvened at 2 p.m., and the record in that case showed that there was a discussion between Kirkman and the substitute trustee on a production of an earnest money amount, but some amount less than the full purchase price. The Court of Appeals, coincidentally enough, this Court of Appeals found that there was no evidence that Kirkman had the ability to tender the purchase price, and it was based on that evidence that Kirkman failed to tender. The evidence in this case is clearly very different. The evidence in the record shows that Mr. Berrizani walked directly up to the substitute trustee trying to explain to him, I have the funds, I have $500,000 in cashier's checks, sell the properties to me, it's 1:13, you agreed to give me until at least 1:30, and the substitute trustee refused to accept that tender. Now, Independent Bank has tried to argue that there was not a meeting of the minds between the parties with regard to the extension of time granted to Sunday Sky, and that it destroys any purported contract between the parties. However, that argument fails to recognize, one, that the agreement for the extension, as explained by the Heck Court, doesn't negate the existence of the valid and enforceable contract under 26.01 of the Texas Business and Commerce Code.
So are you saying we don't have to even, whether they agreed on the time or not come into the analysis at all, or whether or not the documents as a whole satisfy the statute of frauds?
Yes, Your Honor, that's exactly our position here. that because the trial court made a legal determination that the documents taken together does not satisfy the statute of frauds, that reason, or that legal conclusion is erroneous and must be overruled. The factual determination of whether or not there was a oral agreement, what that oral agreement was, those were questions that the jury had to decide. Rule 248 and 166G do not allow the trial court to make factual determinations, and by making a legal determination that the papers held together violated or did not satisfy the statute of frauds, it usurped Sunday Sky's day in court to determine whether or not there was that oral extension, what that oral extension was, and whether or not Sunday Sky had the right to purchase that property. Thank you.
But one more question.
Yes, sir.
Key against Pierce, footnote, I think it's 16, says, "We do not decide whether the statute of frauds does indeed apply to a non-judicial foreclosure sale."
Yes, Your Honor.
That seems like an odd statement for one taking the position that the statute of frauds is satisfied as long as the documents underlying the non-judicial foreclosure sale are produced.
And Your Honor, and we would agree, it does seem odd because the documents together show the material terms of the agreements between the party, the state, what the property, where the property is, how it should be sold, the warranted deed provided to the winner with the highest bid. I think this footnote just shows that the foreclosure universe is somewhat separate and kind of different to a normal sale for property with regard to an options kind of contract that Your Honor brought up earlier. Thank you.
Thank you. Ms. Robertson, the appellee.
Thank you, Your Honor. May it please the court. I'm going to jump right in. There's no fact issues here because what the trial court was deciding were two questions of law. Whether a contract satisfies the statute of frauds is a question of law. And whether a contract is enforceable is a question of law.
Would you agree that if there's conflicting evidence about whether the money was produced, whether it wasn't produced, or whether there was a time extension granted, or whether that's a dispute, those all would be factual disputes, and the trial court would have been incorrect in addressing those issues?
I would not agree with that, Your Honor.
No, why not?
Let me tell you why, because even on the meeting of the minds angle, which is what the first judge ruled, Judge Shanklin, Judge Lavonius, I think, heeded those rulings. But here's why. Meeting of the minds, let me get to my notes. Meeting of the minds is decided by an objective standard. It's based on what the parties said and did, and not based on any subjective intent or subjective state of mind. So all Judge Shanklin did, and I think also Judge Lavonius, is looked at what the evidence objectively showed what the parties said and did. And as recounted by Mr. Tufnell, definitely the trustee thought there was one agreement, and the buyer, high bidder, Mr. Barzani, thought there was another agreement. There was not any, the trustee thought the maximum latest time was 1 p.m. based on what was in the narrative. And Mr. Barzani thought that the trustee had given him an extension to 1:15 or 1:20 or 1:30. So when the judge is looking at whether there's a meeting of the minds and thus an enforceable contract, that's all he's looking at.
But if we're talking about what the parties subjectively believe to be the case,
No, we're not.
that's inherently a factual question.
We're not talking about that. It's decided on an objective standard.
I understand what you're saying the standard is. How is that decided on an objective standard? You and I are having a discussion right now about whether we have an agreement on something, but it still comes to the parties' testimony and the evidence on what the parties said that they thought the parties agreed to.
But what it shows is there's no meeting of the minds. I mean, objectively, there was no meeting of the minds. The trustee thought that the latest he could go was 1 PM, and so he reconvened the sale at 12:58.
Do we only look at that
And the other
evidence
people-
based upon what the parties subjectively say they believe? Or do we not assess, in any breach of contract case, you've got an offer and acceptance. Isn't it a fact question on whether the party said, yes, I thought we had an agreement because the person said we did?
But there's cases where meeting of the minds is decided as a matter of law based on the evidence.
I agree.
And that's what I think Judge Shankman was saying here. He was saying, based on the testimony that I've heard, you believe this, and you believe this, there was no meeting of the minds on how the offer was to be accepted.
Well, I have a problem, I guess, with your using what Judge Shanklin said versus the judgment that was rendered by a different judge.
That's an alternative argument we're making, Your Honor. I'm not saying that's the primary argument. We offered that as an alternative basis for affirmance, because that also shows there was not an enforceable contract. And I'm happy to get back to statute of frauds. Which is the
I'm on the
base.
same questioning right now on the meeting of the minds. So assume with me, the trustee did say 1:30, okay, but he does start it at 12:58. There was a meeting of the minds. That would just be a breach of that contract then, right? If he
there's-
started 30 minutes early than what he said?
If there's not a meeting of the minds, then there's no contract formed.
Well, just assume with me, he did say 12:30.
1:30.
1:30, but he starts 30 minutes early. All that's here is just a breach of that contract.
Well, that's what happened in the McDonald case.
Right, and so if we have disinterested witnesses say, hey, yeah, he gave him 1:15, we have some other fact issue that says, yeah, there was a different evidence towards what the meeting of the minds. We thought he said 1:15.
Oh, well, I'm not gonna concede that that's a fact issue, but accepting that the meeting of the minds argument.
Here's the point that I think I'm trying to build on what Justice Yarbrough was saying. The Supreme Court numerous times involving, even in Coker, went back and said, we don't concern ourselves with the subjective beliefs of the parties.
Mhm.
What we are concerned with is what was actually communicated either in the documents or communicated between the parties. So if we look at the evidence of what was actually communicated between the parties, without regard to what anybody subjectively thought, is there not a fact question on whether there was an offer or there was a meeting of the minds, at least on the time?
I don't think there is. I think the way that the judge is required to view the evidence when deciding as a question of law, whether there's an enforceable contract or a contract that satisfies the statute of fraud, she's entitled to look at the objective evidence. So I guess we'll just
So
have to-
what objective evidence would we look at here when we're writing this opinion?
Well, okay, I think it's a bigger picture than just looking at the testimony, because here's the thing. I disagree with Mr. Tufnell too on whether this oral agreement is part of a contract that satisfies the statute of frauds. This testimony about meeting of the minds is about acceptance. It's about offer and acceptance. And so that is an essential element of a contract. It's not something that can be divorced based on his reading of Heck versus City Mortgage.
I agree, but back to my question, what evidence would you have this court discuss if we were to adopt your position and say objectively the other side loses as a matter of law?
Well, the reason that the other side loses as a matter of law is because that agreement is all oral, and so it doesn't satisfy the statute of frauds.
I thought your argument just a minute ago was it's different because the parties had different beliefs about what they thought.
It's two different arguments, because one's about meeting of the minds in an enforceable contract, one's about did we have all the elements shown in the written group of documents.
And I'm trying to focus on the first argument you presented, which was there was not a meeting of the minds, without regard to the statute of frauds issue. How would you have this court assess the evidence and say there is no evidence of a meeting of the minds objectively?
Because if you look at what they said and did, there is definitely no agreement about whether there was an extension of time.
Would you have us disregard then the disinterested witness's statement that
No, it shows there was no agreement too, right?
well, that's why I'm asking. To me, it sounds like he agreed, I'll give you till 1:15.
I know, I don't agree that that's what it shows, I guess. So, I mean, I think objectively the judge was looking at, this is the prior judge too. This was not really argued extensively to Judge Livonius, because we argued this was just an alternative basis.
Well, and that's my problem with this, is if it wasn't argued before the judge who made the decision on the judgment, what difference does it make that it was argued?
Because there is an implied judicial notice of the prior rulings by the same court in the same case. And we talked about that in our brief, Your Honor, that there is I know that Judge Shanklin took judicial notice of all the different hearings and rulings he had made, and then
Well, was there a request that Judge
Livonius.
Livonius take judicial
I
notice?
don't know that there was. I apologize because I didn't focus on that, but there is definitely an implied right for her to do that when
Well,
there's
in
been.
fact, we know in the law in Texas, when a court even expressly says they're taking judicial notice of the file, that doesn't mean you're taking judicial notice of the contents of the statements, but merely the statements occurred, right?
Okay. I mean, I think that might be correct, but I had not focused on the judicial notice aspect of it, Your Honor, I apologize.
Go ahead and go to your statute of frauds argument. I'm sorry to cut you off on that
That's
a while
okay.
ago, but I was
That's
trying to
okay.
make sure
I should
we
have
had
started
covered
with
that
that.
first.
I should have started with that. The Heck case doesn't divorce the oral agreement or the oral discussions that everybody had from there being whether all the essential elements are shown. Because in Heck, that case was only about 510075. And in that case, that agreement was reached not as a condition of sale, but it was something that was discussed during the sale. In our case, the trustee announced the condition before the bidding started, so it is a condition of the sale. And it's also in the narrative that if you need extra time, if you need a reasonable time to tender the funds, you have either until 1, which is what the narrative said, or you have 45 minutes from the start of the sale, which is what he announced.
What do you say with regard to the appellant's argument that the parties can make an oral modification of one of the terms? In this case, the time for the production of the money.
I don't think they can, with respect to the statute of frauds, that's the problem. In Key versus Pierce, it's different because in that case, there was an agreement for 30 minutes to go get the money. He came back within the 30 minutes, he had the money, and the opinion says that he actually handed the check to the trustee and he wouldn't take it.
Okay, so the differences we have between this case and the Key case are, one, there's a dispute about whether there was an agreement to extend the time.
There's an
And
oral, a bunch of oral testimony about that.
And two, there's a disagreement about whether there was an actual tender,
Yes.
physical tender.
Yes.
Are those the two distinguishing factors we have in Key?
Yes, because in Key, the court held, this is the important language. The court, when it said that it satisfied the statute of fraud, said these documents, along with Pierce's tender of the purchase price of $55,069, provide all essential terms of the contract and satisfy the statute of fraud. So in that case, there was acceptance. That's what's missing in our case. And the only way they can prove acceptance, I'm sorry to interrupt you, is through this oral testimony, which you can't use to prove a contract under the statute of frauds.
Okay, what evidence in this case do you disagree about there being a tender?
There was no actual production of the money. And it's interesting, I went back and read all the testimony, and at the beginning of the sale, this Mr. Tang, when the trustee asked if you had cash, Mr. Tang opened up this notebook and showed him that he had all these cashier's checks, but Mr. Kimmel didn't do that on behalf of Sunday Sky. So anyway, but both sides are relying on the same case, the Bachman case, for the definition. But when I went back and I reread it for oral argument, the language in that case supports the trial court's struggle, I guess, with doesn't it require the actual production of the money? And in Bachman, the court said, under the policy, so you have to obviously go by the document, the insurer could stop the running of interest by doing one of three things: payment, tender, or deposit in the registry of the court. If the insurer had done the first or the third, they would have relinquished control of the money. But by the principal reason why the delivery of the check to the clerk falls short of a tender is that it was never actually been tendered to the insured. In other words, physical relinquishment.
Well, but that's, I think, that's the difference of opinion that we're talking about here is that I think the other side is saying that a physical tender is excused if the money is rejected before the physical act takes place.
So that gets me into the whole thing that they never raised excuse with the trial judge, Your Honor. That's a defense to tender, that's a defense. And it's not been pleaded and it was never argued to Judge Livonius during this 166G hearing. And I don't disagree that they have argued, we tried to give him the money and he said no. Yes, they did, but they never asked the court to excuse them from that requirement of acceptance. They've never asked the trial court to do that. So this court can't rely on excuse to reverse if the trial judge never had a chance to consider that as a defense.
They argued to the trial court. I mean, it's on page 47 of the record. Hey, Mr. Bazzari showed up, the trustee said, sorry, I'm not accepting that. So it's like a pre-rejection, so the formal tender is excused. Where are you saying they should have raised that issue other than in a pleading?
Yes, it's required to be pleaded. And I personally think that word never came up. They never asked the judge, they never said, you should reject their argument about lack of tender because we were excused from tendering. We don't have to prove that.
Your authority that it has to be pleaded, I agree that it was under Rule 94, maybe as an affirmative defense, but they're the plaintiffs in this case, so I don't know that they've got to plead it then. So what would be your authority that they've got to physically produce a written pleading saying we're excused from tendering?
It's in our brief, Your Honor. I did not reread that case this morning, I apologize. But I do believe that it is a defense for them. It's a defense to them having to comply with the acceptance essential element of forming a contract. So.
Do they have to use that word, or do they have to say the circumstances were such that we offered to produce the money and it was refused? Doesn't that cover an excuse without
They
using
didn't
that
offer
word?
to produce the money. That's the whole dispute. And he showed up and he said, I'm here, I have the money. Why aren't you selling the property to me? He never showed him the money or even offered to pay the money.
Does he have to show the money if the trustee tells him he is not accepting any money?
I mean, that's certainly our position, yes, based on this.
He
Bachman
still
case.
has to show it,
Has to
even
actually
though
produce.
the trustee says, I'm not accepting it.
Yes, that's our position.
So you would say a formal tender is not excused if a creditor has pre-rejected it?
I think that they have to meet the definition of tender in the Bachman case, and that's what we argued to the trial court. So yes, I do think that they had to try to tender the money. And that's what they did in the Key versus Pierce case. He tried to give him the check, and the court found that was good enough to try to make an acceptance. Your Honor, I was also just going to talk about the cases that we cited where the court did look, where meeting of the minds or an agreement of offer and acceptance was decided as a question of law, like on summary judgment or something like that. We have cited some cases in our brief on that. So it's not that it's always a fact question.
I agree with you, it's not always a fact question.
I mean, go ahead.
My question was, do we not have to take the cases as they come to us, and if there's conflicting testimony about what the parties agreed to, that we may have a fact question on what the parties agreed to?
But I mean, and what the court in these couple cases did was look at what the parties were saying happened, and like this side said that we have an agreement because we did this, this, and this. This side said we don't have an agreement, and then they said based on that evidence we find there's no meeting of the minds. I feel like that is what happened here, is the court was saying there was definitely nobody ever agreeing to an extension. If the court could disagree with me and find that that is not what happened. But I'm just saying there are cases out there where the court looked at the evidence, like I was saying, under an objective standard of what the parties said and did. And the one was the Parker drilling case, which was where they offered some terms, but nobody ever accepted on those terms, but came back with different terms.
On the subjective standards of what the parties said and did, are we to ignore these third-party witnesses that say The trustee said until 1:15.
That's the hardest question in the case. I'm not gonna concede that you should, I'm not gonna concede that that raised a fact issue, because I don't think it did.
What do we do with that evidence then?
Well, you don't even have to get there if you hold that all this discussion about modifying the acceptance essential element of the contract was oral, and you can't consider that oral testimony in deciding whether a handful of documents constituted a contract that met the statute of frauds.
Okay, looking at just the documents then, how are we different from Key?
Because the notice of sale and the deed of trust are the offer. Him showing up with the money within 30 minutes and tendering it is the acceptance. That's what we don't have in our case. And the only evidence we have of any modification to the acceptance is this oral testimony, where you're supposed to be able to show the contract without resort to oral testimony. So if we have, we have the notice of sale and the narrative and the deed of trust that show what our offer was, but we don't have the acceptance. So that's why it's different from Key versus Pierce.
I would agree with you that we are supposed to be able to look at these agreements without resort to oral testimony. But that's in the case of unambiguous contracts. If there's a question here about what the parties agreed to, and a reasonable person would say, there's a disagreement about what the deadline is set, doesn't that mean we have an ambiguous contract and that oral testimony is the way we got to resolve that issue?
It's never been pitched that way, though, Your Honor. It's always been about whether they had proof that that we agreed to modify the acceptance the way they could accept the offer to purchase the property. The trustee testified uncontroverted that he never signed that narrative during the time he had recessed the sale to let Sunday Sky go get the money.
Let me ask you a question I asked the other side just a minute ago. What would you say the standard of reviewing the evidence is here? Do we review it in the same way that we review summary judgment evidence, where we're looking at, we construe all inferences in favor of the non-moving party, and if a reasonable person could have a difference of opinion more than a mere scintilla of evidence?
Well,
You argued preponderance in your brief, so that's why I'm curious.
I thought I had argued that there's a case law that says that, well, since Rule 160, there's case law that says 166G says that even if something might ordinarily be a fact issue, the judge can rule on it as a matter of law because he's decided through the course of the case that reasonable minds could not differ. And I feel like that's what happened here.
So we're looking at whether reasonable minds could differ.
I mean, so that's in there, yes, that's in the case law.
Okay.
And I do think that we cited a case that said this is similar to a summary judgment type resolution. So that may end up, killing me on that, but
Well,
I still don't think.
I'm not disagreeing, I'm saying I think the standard's the same whether it's at that point or whether it's post-trial.
Right, if it's a legal determination that the judge is making, and I do think, like as I said at the very beginning, these are two legal questions of law that Judge Livonius was trying to decide. Did it satisfy the statute of frauds, and was there an enforceable contract?
Any further questions?
Thank you
Thank
very, very much for your attention.
Mr. Tufnell, you'll have 5-minute rebuttal.
Thank you, Justices. I'd like to go ahead and start off by addressing one argument that the appellant, or the appellee argued with respect to the meeting of the minds, that it's this objective standard as to what the parties said and did. And Justice Yarborough, I think you absolutely have nailed the issue here, that what the parties said and did in this case, our reasonable minds can differ as to what they actually did. If we take the substitute trustee at his word and what he said in the narrative for substitute trustee sale, that the parties have until 1 p.m. to tender the cash, then starting the second bid at 12:58 would have already breached that original contract by not giving the time until not giving the winning bidder until 1 p.m. to arrive with the funds. He breached that contract. And if we take out the the oral argument or the issues surrounding, the fact issues surrounding the oral argument between the parties, this case is almost identical to Key, that the documents at issue absolutely satisfy the statute of fraud. Now, as it comes to the tender issue, I do think that the DiGiuseppe case has important parallels to this case I'd like to go over. There was a purchase of a piece of property. And
What case is this?
DiGiuseppe, Your Honor. The citation is 29 Southwest 3rd, 580, Texas Supreme Court case, 2008. There was a purchase property. It questions whether certain earnest money payments were due. And importantly, in that case, a jury made the determination that the plaintiff in that case, DiGiuseppe, was damaged in the amount of less than $300,000. There was no jury question submitted with respect to specific performance. However, post-trial motions granted DiGiuseppe the specific performance of the purchase contract and attorney's fees. So what the Dallas Court of Appeals held was that because there was no factual determination as to whether DiGiuseppe was ready, willing, and able to perform his obligations, the trial court's post-trial motions must be reversed and remanded, and the Supreme Court affirmed that decision. So in this case, Your Honor, we believe, or Sunday Sky is arguing, that there was no factual determination as to whether Mr. Barazani arrived and was ready, willing, and able to make those payments.
What do you mean there's no factual determination of that part?
So Sunday Sky requested a jury to make the factual determinations in this case. So that means the jury has the right to hear witnesses, to determine the weight and credibility of their testimony. We would be entitled to have the substitute trustee sit on the stand, have Mr. Tang, Mr. Barazani, all make their claims and have 12 people decide the facts.
I agree with you generally that that's what would occur if the case went to the trial court, but because we're here by pretrial motion that's being treated in many ways sort of like a summary judgment motion, don't we only look at the evidence presented at the time of what your client said to do to prove that they were ready, willing, and able?
And I agree with you, Your Honor, that you would need to go off the facts in the record. And the facts in the record clearly state that Mr. Barazani arrived at the foreclosure sale within the time period that was agreed to between the parties as corroborated by a disinterested third party.
What other evidence is there beyond him saying, I've got the funds?
That's the only, testimony is the only evidence that we have in this case at this point, because in large part, we argue that the factual determinations were usurped from the jury in this case. That in making the legal determinations that the trial court judge is allowed to do under Rule 166G and 248, there were factual issues that still need to be determined in order for her to make those legal arguments, or those legal determinations. And with that, Justices, I thank you all very much for your attention and questions, and hope that we come to what we believe is the right conclusion. Thank you.
Any further questions? Thank you. The case is submitted. We appreciate you traveling to Amarillo on what was not the coldest day of the week. I think next week is going to be the coldest that we've had in a while. But safe travels.